function regarding taxation related contracts. I was a student of Panjab University. I did my graduation from university, not from campus, but SD college. I am also alumni of this university. I have been directed to create this program. You see, our job is to hear and write only. This lecture is with the academic part. The teachers are the best persons who can give a lecture. We only write judgments after hearing some comments and all that. This is our job basically. In function also, if we go, normally we are at the end, so many speakers have spoken, so thereafter our number comes to sum up the issues. So that's our job basically, either in court or function also. But we all are here, I think, इस एरिया के लोग हैं ना, सारे हिंदी पंजाबी से समझते हैं सारे. ये गुरु मंत्र मैं आपको दे देता हूँ. When you are studying in law school or wherever you are studying, just respect your teacher and do whatever they want, whatever they direct you. Otherwise, आप जिंदगी में कहीं भी पहुंच जाओगे तो वो आपका टेस्ट लेने के लिए आपको बार बार गलत करेंगे. This is what they are doing. And it's very difficult. And ye don't think anyone of the teachers here may not have taught me. वो बैटन पास ऑन करते रहते हैं कि ये इसको जरूर बुला के हम दोबारा टेस्ट लेंगे. So this is all what happens. So always respect your teacher and do whatever you can do best. क्योंकि टीचर वही है. The students have to take from that. वही क्लास में सबको इक्वली वही पढ़ा है. There are 30-40 students or 50 students in a class. They don't differentiate. Lecture वही है. This is your capacity what to absorb out of it. और ये बड़ा difficult in a way काम है. For the reason kind of adult education है. For adult education there is a problem. It's very easy to teach any fresh mind law student, the बच्चे हैं छोटे, because their slate is clean. You have your own knowledge also, and we know nowadays the Google Baba is available everywhere. The moment the teacher says you something, you immediately open the Google Baba. It's the best teacher and see, no, this line is wrongly said by the teacher. Now you never know whether that Google is also saying right or wrong. Google has information. It's not that it is correct or. This is what the teacher can teach you. How to take right or wrong things. So this is the best part, I think, of the life. Though in this profession or maybe in other professions also, the learning never stops. The moment you stop learning, that will be the end of your knowledge. And you know the things are moving so fast now in life. Whatever we read in school or the college, or maybe the cases we dealt with when I was admitted in 2006, nothing same. Every day in the same provision of law, same act, you are getting new kind of problems in new facts. So I am fortunate to be there in 4 courts. From Chandigarh I went to J&K, then Calcutta, then Allahabad. Litigation is different. Law is same. So this is how you learn. But always keep your mind open to learn. And these lectures are not kept just for the sake of it, some memorial lecture. You have to learn from the name of the person, his life, what he has done in his life. And sometimes we need to have the role models also. That what we learn from somebody's life, who have done a lot in their life. So with these words, now the subject is, yes, the Constitution we all know, adopted on 26th of November 1949, basic document, mother document, as we say. Little bit I will be touching about the living document part in Article 21, how the Article 21 has grown, with same few words in that article. I remember earlier there used to be some period, I think on 26th, the Constitution Day, 26th November, there used to be recital of the fundamental duties also, in courts also, staff and everybody will assemble and just read the fundamental duties, because we all are forgetting our duties. They are all after rights. This is the main problem in the society now. We all know our rights very well, fundamental rights. Wherever the rights are there, we know that this is the duty of so and so, this is the duty of so and so, this is my right, but I forget my duties out of it. And this is the main problem. It's all balanced basically. Whatever somebody's right is there, corresponding duty is there. If you say there has to be a policeman at the crossing to monitor the traffic, it is your duty also to see how you have to move. But our mindset is kind of that we don't see the red light, we see the cop standing there. And then we move. So this all, we have to be law-abiding also, to know all our duties, what we have to discharge. If we start with historical background, in 1946, framing of the Constitution, I will give you some little idea about it. Cabinet Mission Plan of 1946, Constituent Assembly was constituted. In December 47, there were 299 members in that. And first meeting was on December 9, 46. And it took about 2 years, 11 months and 18 days for drafting of the Constitution. And if you are a student of Constitution, I think everybody should know about the Constitution. See the quality of debate which was there. There are 5 or 6 volumes of constitutional debates available. The input given by all the members of the Constituent Assembly, that how they were framing a document which is to govern our country for periods to come, centuries to come. And draft was finally, they had 11 sessions covering 165 days, the Assembly. And finally the draft was approved on 26th November 1949. Now if you see, we need not go into all that. There are many provisions in the Constitution that have been taken guidance or adopted from different countries. Whatever best suited was adopted, or the ideas were taken from that. But what I can share is there were 7,500 amendments which were proposed during the course of discussion in the Assembly when the first draft was presented, and 2,500 of them were accepted also. And the Dr. Ambedkar also had given the credit to, in the drafting committee, to S.N. Mukherjee, a senior civil servant, for simplifying the language and framing of the provisions also, because that's more important. And we all know Dr. Ambedkar was the chairman of the drafting committee, the main artist behind it. And 25th February 48, the draft was submitted. Final draft, he said, and it consisted 315 articles in 18 parts and 8 schedules. But thereafter also discussions, because it was again draft only. And thereafter again debated, this is all historical, and finally approval on 26th November 1949. The first idea behind the framing of the document was that they also wanted to make it a flexible document so that it could address the need of evolving society, because we just got independence. So with the passage of time we had to grow as a country.
and our needs with the time would have changed. So there is one important article, 368 in the Constitution, which talks about amendment of the Constitution. There also we see that different parameters or different kind of majority or the assent by the states was required for different amendments. So for some amendments, simple majority; for some amendment, yes, you need the assent of the state also. But one fact is there that there were two amendments, two insertions made in this article which were declared to be ultra-virus in Minerva Bell's case, in subsection clauses 4 and 5. Now, if we see the discussion about the document being a living document, what one of the members of the Constituent Assembly, H.B. Kamath, said, when a storm breaks out, it is the flexible little plants, blades of grass that withstand the storm. They do not break because they bend, they are flexible, but the mighty trees that stand rigid break, and they are uprooted in a storm. Therefore, I feel that when a social storm is blowing, if we want to resist the storm, this is not the way to proceed about it. We must make the Constitution flexible and able to bend to the social changes. This was the vision way back in 49 we said when the Constitution was being drafted. Another member, Rajesh Brindal, I am for a flexible Constitution and not a rigid Constitution. There is likely to arise a revolutionary situation in Asia in the near future. Just see the vision. In order to meet that situation, the government of India should not be fettered in any way whatsoever. There is another reason why I am in favor of a flexible constitution, as opposed to a rigid constitution. I hold the opinion that we are passing through a period of decadence. It is only the establishment of a new social order that we will be in a position to sense the needs of the coming century. For heaven's sake, do not make your constitution rigid. Another reason why I am in favor of flexible constitution, I hope friends will excuse me for my bluntness. The fear of the combination of the north and Hindi-speaking regions over the south and non-Hindi-speaking areas not related with this constitution. We have framed a middle-class constitution. We have done all which could be done to prevent the establishment of socialism and a unitary state in this country. So this is what their opinion was. Then another member, Mahavir Tyagi. If it is not flexible, it will naturally become brittle and will break if it is hit even slightly. Do not let your constitution become so hard as to acquire brittleness. It will break. Therefore, I submit, sir, we should provide for a convenient change in the constitution. And Dr. B.R. Ambedkar, in his final speech, he said, Constitution is not a mere lawyer's document. It's a beacon of life, and its spirit is always the spirit of age. He cautioned the working of Constitution does not depend on the document itself. Ultimately, its effect depends on those tasked with implementing it. This is very important, because the document remains the same, the laws remain the same. We say the implementation sometimes is bad. However good a Constitution may be, who are called to work it happen to be a bad lot. However bad a Constitution may be, it may turn out to be good if those who are called out to work happen to be good lot. So this is what the opinion of the Constitution maker, the framers was. So our beginning was from that only. And you see, it's a living organism, we say, living document. There is another document for all our laws basically tested on the touchstone of the provisions in the Constitution. And with the change of time, the meaning changes. But changing times illustrate and eliminates the meaning of the same expression. This is what we are seeing with regard to many new interpretations which continue coming. And this living doctrine, if you see the Canadian Constitution, there also the courts have that view. If you go to the American Constitution, they have the rigid will. They say whatever the Constitution was framed at the time of its framing, whatever the provisions were there, the same should be as such. If they want to change anything, there has to be amendment. People's will has to be taken, so that position is not in our country. Europe European Union also, the European Court of Human Rights also interprets the Convention on Human Rights as a living instrument, because they go with the society, with the change in society. Whatever is the requirement is,